Judgment in the matter of Newcastle upon Tyne Hospital's NHS Foundation Trust versus Haywood.
When a contract of employment provides that it may be terminated, either by the employer or by the employee, giving the other a certain minimum period of notice, what is meant by giving notice? In particular, if an employer gives notice to an employee by letter, when does the notice period begin? Is it when the letter ought to have arrived at the employee's address, or when it actually did arrive, or when the employee actually received it and had either read it or had a reasonable opportunity of doing so? It may be important either to the employer or to the employee or to both to know exactly when the contract of employment comes to an end. Other rights and liabilities may depend upon it. In this particular case, the employee's pension entitlement depends upon the date when the notice took effect. Mrs. Haywood was employed for many years by various bodies in the National Health Service, most recently by the Newcastle upon Tyne Hospital's NHS Foundation Trust, to which her employment was transferred on the 1st of April 2011. Her contract provided for a minimum period of 12 weeks' notice on either side. The Trust quickly formed the view that her post was redundant. At a meeting to discuss her possible redundancy, she asked that no decision be taken while she was away on an authorised holiday, but the Trust did not agree to that. A letter giving written notice of termination was sent to her home address by recorded delivery on the 20th of April 2011, while Mrs. Haywood and her husband were out of the country. A recorded delivery slip was left there on the 21st of April. On the 26th of April, her father-in-law, who was keeping an eye on the house while they were away, found the slip, collected the letter from the local sorting office, and left it at their home. It was waiting for Mrs. Haywood and her husband when they arrived home in the early hours of the 27th of April, and she read it later that day. It was critical to her pension entitlement whether she was given notice on or before the 26th of April or on the 27th of April. If the 12 weeks expired on her 50th birthday, she would be entitled to a non-actuarially reduced early retirement pension. If it expired before her 50th birthday, she would not. Notice given on the 27th of April would expire on her 50th birthday. Notice given before that would expire earlier. There's nothing to prevent the parties to a contract of employment making express provision in their contract for how notice is to be given and when it is to take effect. But in this and in many other cases, this is not done. The question, therefore, is what terms are to be implied into such contracts. The Trust argued that there was a common law rule, principally derived from landlord and tenant cases, providing that notice is given when the letter arrives at the recipient's address. Mrs. Haywood, relying on the approach of the Employment Appeal Tribunal in employment cases, argued that notice only took effect when it had actually been received by the employer and the employee had either read it or had a reasonable opportunity of doing so. The claimant's argument succeeded before the trial judge and by a majority in the Court of Appeal. On appeal to this court is also divided. Lord Briggs, with whom Lord Lloyd-Jones agrees, would have found that the common law cases had long established a rule in relationship contracts terminable on notice that written notice is given when the document containing it is duly delivered by hand or by post to the recipient's address, regardless of whether he or his agent is there to receive it. The majority, Lady Hale, who gives the leading judgment, with which Lord Wilson and Lady Black agree, hold that the approach consistently taken by the Employment Appeal Tribunal is correct. First, the common law rule in non-employment cases is not as clear and universal as suggested. In a concurring judgment, Lady Black reviews the cases in detail and concludes that, insofar as there was any clear principle, it revolved around delivery to the recipient's agent, whether a household servant, professional agent, or family member, who would be expected to take in communications for the intended recipient as part of their role. The court was unanimously of the view that the claimant's father-in-law was not her agent in this sense. Second, the Employment Appeal Tribunal is an expert body familiar with employment practices and with the general merits in employment cases. Third, this particular contract was made when those cases were thought to represent the law. Fourth, there was no reason to suppose that this had caused any real difficulties in practice. The employer could give notice to expire on a particular day, making sure that it arrived in good time for the required notice period to elapse. Alternatively, express provision could be made in the contract of employment. Fifth, it was important for both employer and employee to know when the employment had come to an end. The rule should be the same for both summary dismissals without notice and dismissal on notice. Accordingly, the Trust's appeal is dismissed. The Court will now adjourn.